Hello, CRES students. This is Sam Zakarian again, one of the instructors for the Chicago Real Estate School. This is going to be Chapter 15. This session deals with Chapter 15. Now, Chapter 15 is pretty simple chapter. It deals with property management and also with leases. And a lot of us had experience with leases, so this should not be that difficult. So we're going to start off again. We have the 10th edition starting off on page 238. Let's start off at that first paragraph. You can highlight. They talk about most major cities. They have associations of building and property owners and managers, and they have a list of them up there. It's interesting to know. But the paragraph right after those bullets, where it says a property manager, I'd like you to highlight and put an X by that. Let me read this to you. It says, in addition to leasing, managing, marketing, and overall maintenance of real estate owned by others, it is expected that the property manager function as a market analyst, residential leasing agent, accountant, advertising specialist, and maintenance person all at the same time. Now, the very next line, it says that the property manager has three principal responsibilities. I'd like you to highlight and put an X by all three of these. The first one is achieve the objectives of the property manager, which is the next two bullets: generate income for the owners and preserve and increase the value of the investment property. Now, the next paragraph you can highlight, put an X by that one. Now, to work as a property manager, you must have a managing broker's license here in Illinois. In order to get a managing broker's license, you must be licensed as a real estate broker for at least 2 years. Now, in Illinois, which is the next paragraph where it says, however, in Illinois, the exceptions to being licensed, if you own your own property, you don't have to be licensed to own your own property. And also, if you live in a building that you manage, you don't have to be licensed. Otherwise, you must have a license managing brokers credentials in order to manage property for someone else. Okay, let's go to page 239 next. Let's talk about, it's about about a quarter of the way down where it says property manager's responsibility, financial reports. You can highlight the next couple lines. Of course, a property manager should turn in financial reports, usually on a monthly basis, so at least the property owner can see how well the property is being managed. The next paragraph, operating budget, you can highlight, put an X by that one. Now, the operating budget, they do a projection based on anticipated revenues and expenses. And they would do a 1-year projection, a 3-year, 5-year, even a 10-year projection for the owners. That's what they would do. Income, you can highlight, put an X by that one. Income is the money that they collect from rents, maybe from parking, from vending machines, laundry machines, things like that. Just any income that comes into the property. Expenses, you can highlight, put an X by that one. Expenses will include anything. I mean, just all the expenses. We're talking about utilities, talking about insurance, property taxes, janitorial, maintenance, repairs, scavenger, management, janitorial. So those are the expenses. And then last paragraph, you could just highlight, they do a cash flow report. This way the owner can see how well the property is being managed. Now, let's go on to page 240. Profit and loss statement. This is near the top. They should have a profit and loss statement. This way, usually their accountant will handle this. And again, in case they want to sell the property, that people will be easily be able to analyze the value of that property. Now, that's it on this page. Let's go on to page 241. Actually, towards the very bottom, where it says residential leasing agent license. Now, there are 3 licenses. I'm going to talk about those in chapter 16, the very next chapter. But there is a license in Illinois called a residential leasing agent license. Now, this is a limited scope license that just enables that person with that particular license to engage in leasing residential property. They have to also, a leasing agent must work for a sponsoring broker. Now, at the very bottom here on 241, they talk about a management plan. Now, the first step in taking over the management of a property for someone else is create a management plan as to what some of the things will be on a management plan. On top of page 242, they outline the owner's objectives. Now, the owner's objectives, of course, they have 3 bullets near the top, and you can highlight, put an X by that. Of course, they want to make money and preserve the integrity of the property, of course. Also, the regional and neighborhood market and the property itself. That's the first step, is create the management plan. The second step is called the management agreement. Now, the management agreement that's created between the property manager and the owner is so that everyone knows exactly, especially a property manager, knows what their job is, what their duties are. And some of the things that will be included in a management plan, I'd like you to actually go over all these bullets. In fact, I'd like you to put X's by them. I want you to be familiar with them. These are all part of the management agreement. There's actually 2 more bullets on top of page 243 as well. Now, after those 2 bullets on top of page 243, setting rental rates. It says rental rates are influenced primarily by supply and demand. Now, a good property manager should be very much in tune as to what similar properties are selling for. What they should do is conduct a survey, go out and walk around the neighborhood, see what similar size apartments, bedrooms are renting for in the area. A lot of times, most management companies, especially larger companies, they post everything on the door itself. They should go on Craigslist to check what apartments are renting for in the area. They got to know their area. Now, right in the middle of the page, a 2-line paragraph starting off with the elevated level of vacancy. I'd like you to highlight, put an X by that one. A elevated level of vacancy, you got a much higher vacancy, might indicate poor management or a defective or undesirable property. On the other hand, if you have a high occupancy rate, that means that the rents are too low. I want you to understand something, that when you're working with a investor who wants to sell their property, you should always ask for the schedule, what's called Schedule E. And that's what they file with the IRS. And get the last 3 years worth. Now, not always accurate, but it gives you a good indication as to what kind of expenses and incomes coming into that property, that particular property. And if you're working with a seller wants to sell his property, says, I never have any vacancies, never had a vacancy in 5 years. Well, there's only one reason for that. The rents are too low. You are going to have vacancies. People move for different reasons. They got a new job, relocated somewhere else. Maybe they need more space. Maybe they bought a car. There's no parking in that particular neighborhood. There will be vacancies. So you don't go with anything that says no vacancies. I mean, if you list a property and the owner says, we never have any vacancies, not over the last 5 years, and you give that information to a potential investor, they go to a bank to apply for a loan, no vacancies, well, guess what? The bank will probably throw them out. You got to have a vacancy factor. We talked about that in chapter 7, under the income approach. If you remember that, we did that under the income approach. Now, collecting rents. I want you to highlight, put an X by that one. Of course, a good property manager should only allow tenants to occupy the property after they've done they screen the tenants. They check them for they have employment. They could do a eviction. They could do a criminal background check. So they got to make sure that the tenant that's moving in is able to meet their monthly financial obligations. let's go on to page 244 now. On page 244, I want to point out a couple of things. That first paragraph starts off with an addition. I like you to highlight and put an X by this, and I want you to remember this. Now, in the state of Illinois, if a owner has more than 25 residential units, and they don't have to be in the same complex, they could be spread out all throughout the state. 25 residential units, and they are holding security deposit. The owner must pay interest on that security deposit once a year. If they live there for more than 6 months. If they don't, they could get fined 3 times what the security deposit is. It really turned into a kind of a pain in the butt for the owners, that a lot of them are getting away from that, and they're doing a non-refundable move-in fee. We're going to talk about that a little bit later, but this is going to be brought up again. They have 25 units or more here in Illinois, then they must pay interest if they're holding security deposit once a year. Otherwise, they could get fined hefty fines for that. Maintaining the property. No, I'm sorry. The paragraph, couple paragraphs above. Maintaining good relations with tenants. You can highlight, put an X by that one. Now, a good property manager should have a very good communication system with their tenants. So the tenants could come in if they have something wrong with the property, toilets blocked up, water's leaking from the apartment above. They got to have a good communication system so they can take care of any problems. There's no heat, there's whatever it might be in that property. So having a good communication system, it helps maintain good relationships with tenants. The very next paragraph, the property manager, highlight, put an X by that. A property manager must be able to handle residents who do not pay their rent on time or break building regulations. Of course, people have a right to have a party. It might be someone's birthday, anniversary, graduation, something like that. But they can't be partying all the time. They have to respect all the other tenants. Now, I want to talk about something that's very important for your real estate career. Now, in Cook County, just in Cook County, it's federal law that you cannot advertise a property and say no Section 8 tenants. Now, Section 8, let me explain a little bit about Section 8 and I'll go more into it. Section 8 is under HUD, and what it is, provides a majority of the rent to the landlord for a tenant. A tenant pays only a small portion of their income that goes towards the rent, and that's called Section 8 voucher. Now, an agent cannot advertise no Section 8 tenants. Now, the property does have to qualify. The property has to qualify, which means HUD will come out there and they'll take about 100 pictures. There's a 20-page report. Everything has to be in perfect working order. Now, and the rent, they pay slightly higher than market value rent. Now, if a tenant decides who's on a Section 8 voucher, bust up everything, they could get kicked off of Section 8. And guess what? They don't want to get kicked off of there because it's a long wait. Right now, it's about 7-8 year waiting list to get onto Section 8 subsidized housing. So they're going to really maintain the property. I know a lot of investors, they love Section 8 tenants. The money's always there. Tenants are very good. So just keep that in mind. Okay. Again, the property has to qualify. Not every property qualifies. And the owner doesn't have to make the property qualify. They don't have to. So, now, maintaining the property. I like to highlight, put an X by that. One of the most important functions of a property manager is the supervision of the property's maintenance. A manager must learn to balance services provided with their costs and satisfy the tenant's needs while minimizing operating expenses. This skip down 2 paragraphs, just the first line of that paragraph, highlight, put an X by it. The primary maintenance objective is to protect the physical integrity of the property over the long term. That sounds like an answer to a possible test question. I'll read that again. The primary maintenance objective is to protect the physical integrity of the property over the long term. For example, preserving the property by repainting the exterior or replacing heating systems help decrease long-term maintenance costs. Keeping the property in good condition requires 4 types of maintenance. Like it a highlight and put an X by all 4 of these bullets. The first one is called preventive maintenance. Now, preventive maintenance is maybe you have your heating guy come out there in the summer, in September, to check out the boiler, making sure the water levels are good, tubes aren't leaking, just make sure whatever chemicals they might need to make sure it is in working order. Another preventive maintenance will be they go up on the roof and they do a roof check, because many times in the fall they do this because sometimes you have these little hairline cracks in the roof, which could be patched up with a bucket of tar. But if you ignore those things in the fall, what happens in the winter, those little hairline cracks will turn into big gaps. Then you have big problems there. Next bullet is called repair and corrective maintenance. That's when something breaks down, when the furnace breaks down. A leaky toilet is a repair and corrective maintenance issue when something actually breaks down. The next one is called routine maintenance. Now, routine maintenance is where the property manager makes sure they shovel the snow, they cut the grass, they vacuum the hallways, they just maintain the property. And then we have construction. Now, construction, we're talking about, they call it new construction sometimes. They talk about updating. Now, to update bedrooms, living room, usually, you paint the walls, the ceilings, you replace the carpet or refinish the floors. That's all it takes. It's not that expensive. Your most expensive rooms are your bathrooms and your kitchens. Replacing the cabinets, setting up the tile on the floor, replacing the appliances. They get very, very expensive, but having newer kitchens and newer bathrooms in the apartments adds value to the property. But not only does it add value to the property, usually a landlord or property manager will be able to command a higher rent. Tenants are willing to pay more money for a apartment with new kitchens and new bathrooms. They just like that. It does add value to the property as well. So now all those things I talked about is the bottom of this page and also the next page. I already mentioned that. The very bottom though of page 245, handling environmental issues. You can highlight that. Now it is anything built before 1978, even if they're renting, the agent must provide the lead-based paint disclosure and a pamphlet on the hazards of lead-based paint. And it's up to the buyer if they want to pay. The buyer has to pay for do a assessment if there happens to be any lead paint included in that property. Now, let's go on to page 246. Starting with the second paragraph, Americans with the Disability Act. I like it to highlight and put X by that paragraph and the next 1, 2, 3 paragraphs, and then the bullets underneath. Now, ADA, Americans with the Disability Act. We talked about this earlier in chapter 14 under fair housing. But now, just to give you a reminder, because this is important, under ADA, anything that's open to the general public must be ADA accessible. Talking about movie theaters, I mentioned, talking about banks, restaurants, real estate offices, any business should be ADA accessible. Also, I mentioned this Title I of ADA. If you have a company with more than 15 employees and you hire someone that has a disability and they need reasonable modifications, well, the owner of that company must provide reasonable accommodations for that particular employee. Like I said, maybe a special desk to accommodate a wheelchair, grab bars in a bathroom. Those are reasonable modifications that could be done. Now, Civil rights laws, well, we talked about that in chapter 14. Now, of course, property manager and the owner too, owner of property, they have to be aware of all the protected classes and make sure that they do not discriminate against any of the protected classes. Now, there are state, federal, county, and city civil rights laws. So make sure you're familiar with them. Once you get licensed, talk to your um, sponsoring broker so you understand exactly what they are. Best thing to do is just don't discriminate. You can't discriminate. So that's the best thing. Again, at the bottom, lead-based paint, anything built before 1978, you have to have a lead-based paint pamphlet and disclosure. Now, I'm going to skip page 247. I mean, you could go over there about security of the tenants. I mean, they got to have a door that locks, that's what they're talking about over there. Make sure no harm comes to the tenant in a building. Let's go on to page 248. Actually, what I want to cover on this page is the very bottom, the very last line where it says leasing real estate. Let's talk about leases now. But before I get into that, there's two things I want to make you aware of. So let me get my board ready up here. Two things, and I've seen these on the state exam. You probably will too. Okay, make sure you write these down. The property manager is not responsible for filing income tax returns for the owner. So the property manager is not responsible for filing income tax returns for the owner. Just because the property manager collects the rents or paying the bills, it is up to the owner to file their own income taxes. That makes a lot of sense, common sense right there. And one more thing I want you to be aware of. Writing this down, I will write this down as well. The property manager cannot make money at the expense of the owner. The property manager cannot make money at the expense of the owner. Meaning this, you hired me to manage your building. You have a 200 unit apartment building. I'm your property manager. So what I did is I went to a local hardware store and I told them, look, I'm now the manager of this building, in this area over here. Um, and I'm going to be buying all my supplies, my cleaning supplies. I need paint, I need glass, locks, whatever I need to maintain this property. So I'm going to run everything through your store. It's a big account. You're going to do really well on this one. But I told the owner of the hardware store that, look, I'm going to give you this business, and I don't care if you jack up the prices on anything. I want a kickback of a 10% or whatever I decide on anything I buy from your store. Cannot make money at the expense of the owner. Now, let's go on to page 249. Now we're going to talk about different types of leases here. So starting on page 249 at the very top, highlight, put an X by that paragraph. A lease is a contract. A lease is a contract. It's for the exclusive possession of that tenant, meaning the landlord can't rent the same apartment to 5 different families. And the landlord automatically has a reversionary right, which means once the lease expires, the landlord gets possession of that property back. The third paragraph down, still on page 249, where it says statute of frauds. Statute of frauds are state laws. We talked about that a couple of times already. Now, 2 things about statute of frauds. Anything that deals with the purchase of real estate must be in writing. Anything that deals with the purchase of real estate must be in writing, statute of frauds. And leases, if they're for more than 1 year, mandatory, must be in writing. The leases for more than 1 year, mandatory, must be in writing. If you and I had a verbal lease for 3 years, that's illegal. Can't do this. Now, just to let you know, leases run with the property. Like if you own an apartment building, you have leases with all your tenants and you sold it to someone else, whoever buys it from you, the leases do not change. The new owner cannot cancel the lease. They cannot raise the rent, not until the lease term expires. I should be aware of that. Now, right in the middle of page 249, estate for years. I'd like you to highlight and put an X by both the next 2 paragraphs, estate for years. Now, the term estate for years is misleading. It's a lease that can be for years, but it also could be for months, could be for weeks, could be for days, could even be for hours. What makes it an estate for years, you have a definite beginning period and a definite termination period. So, I'll give you a question. I would write this down. Chances of you seeing this very, very good. You rented a banquet hall from me. You're going to have some type of function. And let's say this is going to happen on, you're going to rent this banquet hall starting on May 15th. There we go. 2025 at 10 a.m. That's when you're starting this lease. 2, May 15th, 2025 until 8 p.m. 8 p.m. So I'm going to lease a banquet hall to you for you're going to have some type of function. And it's going to start on May 15, 2025 at 10 a.m. and it's going to run to May 15, 2025 until 8 p.m. So it's going to run for 10 hours. Question to you. Is this an estate for years? It's only 8 hours. Or 10 hours, I'm sorry. 10 hours. Is this an estate for years, this 10-hour lease? Yes, it is. Why? Because I have a definite beginning date, definite termination date. This is an estate for years. Make sure you are 100% clear on this situation I just gave you. Estate for years. Definite beginning date, definite termination date. Now, notice to terminate this lease. Is it required? The answer is no. Why? Right here, 8 p.m., get out. It's terminated. That's an estate for a year. Now, the bottom of page 249, estate from period to period. I like you to highlight, put an X by that one. Now, an estate for period to period, most common that I see in the Chicagoland area is a month to month. I mean, people could be there for years, but they're only doing month to month leases. It could be a week to week. Now, if I'm leasing a premises to you on a month to month basis, and I want to make any changes, I need to give you a 30-day notice. If I wanted to raise your rent, if you're on a month to month basis, I need to give you a 30-day notice. If I want to vacate the premises, you're on a month to month basis, I need to give you a 30-day notice. If you're on a month to month lease with me and you wanted to move out, all you need to do is give me 30-day notice. So whatever period we're on, that's how much notice is required to make any changes. If we're on a week to week, then 7 days is required. Now, on page 250, it's near the top. It starts off with an estate from period to period. That paragraph, it's about 10 lines in there. Highlight, put an X by this one. Now, let me just read a few lines and I'm going to take a moment to explain this to you. An estate from period to period may also be created when a tenant with an estate for years remains in possession or holds over after the lease term expires. And this is called a holdover tenancy. So, let me explain this to you. We have a written lease that you're renting this space from me. And your lease expired on, let's say your lease expired on May 31st. I come knocking on the door to make sure you're out. You said to me, look, Sam, my new place isn't ready. I need to stay here for another 6 or 8 weeks. I'll pay you the rent while I'm here. That is called a holdover tenancy. So here's the definition of a holdover tenancy. The tenant occupies the property after the lease expires with the landlord's permission, and they pay rent. Again, holdover tenancy. This is where the tenant occupies the property after the lease expires with the landlord's permission. Holdover tenancy. Then they create a periodic tenancy for that. Now, second paragraph from the bottom. Estate at will. You highlight. Nope, I skipped something. Sorry, I didn't see it. About the middle of the page. The following notices are required by Illinois statute. So I'd like you to just put an X by the first two bullets. A year-to-year tenancy, 60-day notice, month-to-month, 30-day notice. Just put an X by the first two. Now, estate at will now, second paragraph from the bottom. Estate at will means no notice is required to make any changes. No notice to vacate or anything else. That's what estate at will is. Now, let me give you an example of estate at will. I own an apartment building, and you are a tenant in my building. Now, what happened is that the federal government decided they're going to build a new highway right where my building is located, right where you live. Now, they're using our power of eminent domain to take over my building to build this new highway. I'm not sure when this is going to happen, but now I've been given notice by the feds. So I come knocking on your door and says, look, federal government's going to extend the highway. It's going to go right where this building's at. So they're going to tear down the building. I'm not sure when they're going to tear down the building. You can stay here until they do. You're paying me rent while you're staying here. But there's going to come a time that I'm going to knock on your door and I'm going to say, you know what? You need to get out and get out now because this building's coming down tomorrow. That is estate at will. No notice is required. Now, estate at sufferance. The last two lines of this page highlight for the X by this. I don't want you to get this mixed up. Let me explain it. Estate at sufferance actually is one of the lowest estates known under the law. Estate at sufferance is just barely a step above trespassing on someone's property. Now, let me give you an example of estate at sufferance. You and I, we have a written lease. The lease expired on May 31st. I come knocking on your door to make sure you're out. And you said, look, Sam, my new place isn't ready. Not going to be ready for another 6 or 8 weeks. I need to stay here. I'll pay you rent. And I say to you, no, you can't stay here because I have a new tenant moving in tomorrow. You need to get out and get out now. And you don't leave. You occupy the property after the lease expires without the landlord's permission. That's called estate at sufferance, one of the lowest estates under the law. Now, don't get that mixed up with holdover tenancy. Holdover tenancy, the tenant occupies a property after the lease expires with the landlord's permission. And estate at sufferance, tenant occupies a property after the lease expires without the landlord's permission. Then the landlord has to go through the eviction process. Now, let's go on to page 251. About a quarter of the way down where it says under types of leases, gross lease. Highlight, put an X by that, gross lease. I want you to write down this word next to those words, gross lease. I want you to write down the word apartments. Apartments. Now, gross lease is used with apartments. This is where the tenant pays a flat fee each and every month. The landlord's responsible for paying the taxes and repairs and maintenance and scavenger and everything else. Used with apartments, gross lease. Again, tenant pays a flat fee each and every month. Landlord winds up taking care of all the expenses on the property. Very common. The next section, net lease. Highlight, put an X by the next two paragraphs. This is called a net lease, also called a net lease, also called a triple net lease. Net, triple net lease. First of all, write down the word commercial next to net lease. Commercial. This is used on commercial property. This is where the tenant not only pays a flat fee each and every month, they pay some or maybe all of the variable expenses, including taxes, insurance, repairs, maintenance. Net, triple net lease used for commercial. The next section, percentage lease. Highlight, put an X by that. Now, in a percentage lease, this is where the tenant not only pays a flat fee each and every month, they pay a percent of their income from their property also happens to go towards rent. So I am going to give you a couple of problems here regarding percentage leases. Here's your first problem. Let's see this too. The rent. Second. The rent is $3,200
$200 a month. Or 10% of the gross sales over 600,000 a year. Whichever is greater. At the top of this stock. Real good chance you're going to see something similar to over 600,000 a year. Sorry, I forgot to put that part in. Whichever is greater. Gross sales. For $1 million a year. Question is, how much rent did the tenant pay last year? So here's the problem. The rent is $3,200 a month, or 10% of gross sales over 600,000 a year, whichever happens to be greater. Gross sales were $1 million last year. So the question is, how much rent did the tenant pay last year? So there's two steps involved on this one. You take 3,200 a month times 12 months. And that's going to equal 38,400 a month. A year, excuse me. That's for the year. The other part, so the gross sales were $1 million. They don't pay on the first 600,000. The first 600,000 is exempt. So we minus the 600,000, which gives us 400,000. 400,000 times 10% equals $40,000. So the question is, how much rent did they pay last year? And the answer is 40,000. Now here's how this works. Every month the tenant's paying 3,200 each and every month.
to the manager. And they paid 38,400 for the year, should have paid 440,000. So at the end of the year, the person that owns the who's renting the space will wind up giving them an additional $1,600 to make up the total 40,000. Now, this is called a percentage lease. This is used in any type of retail stores. Write that down. Any type of retail stores. Now, you think this is common? Yes, it's very common. Any retail store, any shopping mall in this country, they all use a percentage lease. They all have a percentage lease. What happens and how this works out? Let's say I manage a shopping mall and you want to rent a certain space from me. Well, I need so much money for the square footage, 3,200 a month. Now, if you're doing well in your business, then I get some of the action off of that, because if you're doing well in your business, it's going to cost me more money for things like security and janitorial and extra dumpsters, things like that. That's why this is very, very common. Very common. Now, let me give you a similar type problem, similar to this. And want you to be familiar with this one as well. So, go and give us a new plate. Okay, here's the other problem. Your rent is 2,500 a month. A month. Plus 3% of gross sales. Over $950,000 a year. Gross sales, uh, $1,025,000 for the year. Now, question is, you got to pay attention to the question. What was the average monthly? Rent? What was the average monthly rent? Okay, so gross sales was $1,025,000 for the entire year. The first 950,000 is exempt.
which leaves me $75,000, which I'm going to multiply by 3%, which equals 2,250 for the year. Divide that by 12 months. That will equal $187.50 a month. So the rent is $3,200 a month. We add the average of $187.50 a month, $187.50. So the average monthly rent came out to, oops, I made a mistake. Hold on. $2,500 a month. We clear that up. $2,500 a month. So the average monthly rent came out to $2,687.50. That is their answer. Very common with shopping malls. Want you to be familiar with. Now, a variable lease. Let's talk about a variable. Highlight, put an X by variable lease. This is used on commercial, usually long-term leases. Now, this is called a variable lease. This is also called a step-up lease. It's also called a escalator lease. It has a lot of different names. A graduated lease. Let me explain how this one works. Okay. I'm going to rent a commercial space to you for your business. And we're going to sign a 10-year lease. Now, it's not fair to you that I'm going to start the rent up here where it should be in 10 years from now. That's not fair to you. It's not fair to me that my rents are going to be down here at this level for the next 10 years. That's not fair either. So here's what we do. The first year, the rent's at this level down here. We have a slight increase and it stays at that level the second year, third year. Each and every year for the term of this lease, we have a slight increase over that term of that lease. It looks like steps, step up lease, escalators, what it looks like. Graduated lease, that's what it is. Now, the last couple words on here is called the ground lease. It continues on the next page. First paragraph on page 252. A ground lease now. A ground lease, it's a lot more common than a lot of people think. I own some vacant land, and I'm going to lease my land to you, and you're going to build a building on there for your business. By the way, once that lease terminates, whatever you build on there now belongs to me, because anytime you add anything to real property, becomes part of that real property. That's a ground lease. Very, very common with a lot of big chains and stuff like that. Oil and gas leases, you got to highlight that one too. Now, oil and gas leases, this is where actually a lot of oil companies have leased out millions and millions and millions of acres of land all throughout the United States, the Montana, Dakotas, and Oklahoma, Texas. They lease this land from the farmers so they could drill for oil, but they're not really drilling for oil. They're actually trying to prevent other oil companies from drilling. I mean, farmers graze their cattle and grow their crops over there, but if they drill for oil, the landowner will get a percent of the oil. But basically what they're doing, as I said, they're trying to keep them out. Lease with an option to purchase. This is more with residential than anything else. Lease with an option to purchase means that I will rent a house from you
and I'm gonna be paying you rent, but a small portion of that rent's gonna actually be applied towards the down payment if I exercise my right to purchase that property. That's what that is. More common with residential. Now, a sales leaseback. We talked about a sales leaseback. It was in chapter 6. Usually happens with industrial property. I own a factory. I want to sell my factory to you. Let's talk about the benefits to me and then the benefits to you. So I own a factory building. I'm going to sell my building to you. You're the investor. I want to sign a long-term lease there. Now let's talk about benefits to me at first. One benefit to me, I get to stay in the same location. So I don't have to worry about losing my employees, don't have to worry about losing my clients. Another benefit to me, when I sold my property to you, your bank gave me money. You're the owner right now. And that I freed up a lot of the equity in my property. I freed up a lot of the equity in my property. I could take that money, pay down debt, retool, become more efficient in my factory. Another benefit to me is I'm signing a long-term lease with you. I'm going to be paying you rent. The rent I'm paying you every month is a business expense for me. It's a business expense. Now, those are my benefits, which are good. Let's talk about your benefits as the new owner. Well, one thing, whenever you buy any investment property, the owner has a right to write off what we call depreciation. It's a paper loss, but they're allowed to do that. That's one benefit. Another benefit, you don't have to worry about having any vacancy or anything. I will sign a long-term lease with you. And the other thing is, I got the money. Your bank just gave me quite a bit of money for the equity in my property. So you don't have to worry about me defaulting. And another benefit to you, since this was my building, I know the mechanics of it. There'll probably be less wear and tear for you because I would know how to handle it. So that is a sales leaseback. Now, on a state exam, I want you to be familiar with this. The owner becomes the tenant or the lessee. The investor becomes the landlord or the lessor. That's what a sales leaseback is. Now, at the very bottom, requirements for a valid lease. A lease, again, is a contract, so it must have the same essential elements of any contract. First bullet, capacity to contract. A minor cannot sign a lease. A minor cannot sign a lease under any circumstance. Okay, I'm going to mention something to you. Please pay attention to what I'm going to say right now. A father and a 17-year-old son signed a lease. Question is, what's the status of the lease? Pay attention to this question. Pay attention to the answer. A father and a 17-year-old son signed a lease. Question is, what is the status of that lease? Is it valid, void, voidable, or unenforceable? Very important question, because I'm pretty sure all of you are going to see this. I'm going to repeat it. A father and a 17-year-old son signed a lease to rent an apartment. What is the status of that lease? Valid, void, voidable, or unenforceable? The answer is void, void. A minor cannot sign a lease under any circumstance. A minor could buy a property, but a minor could never sign a lease. Even if they have 10 adults, a minor can never sign a lease. It will always be void. Always. So please remember. So the first bullet, they need the capacity to enter into a contract, meaning that they can't be mentally challenged. They can't be under the influence of drugs or alcohol, and they cannot be a minor. Next bullet, make sure you have X's by all 4 of these at the bottom. It must be for legal objective. I can't rent an apartment to you, and then next thing you know, you're going to turn into a nightclub or something like that. It must be for some legal reason. The next bullet, we need an offer and acceptance. Offer and acceptance.
We have to have an agreement, meeting of the mind. Okay, what building, what address I'm gonna rent the apartment to? What unit number? What's the rent gonna be? What's the term of the lease? We have to be precise. The last thing is consideration. Consideration. Rent is consideration. Rent is consideration for the use of the premises. Now, let's go on to page 253 under possession of the premises. I want you to, that's about a third of the way down. I want you to highlight, put a X by that one. The lessor, as the owner of the real estate, is bound by the implied covenant of quiet enjoyment. The landlord must provide quiet enjoyment. Now, quiet enjoyment has nothing to do with the neighbor's dog barking or someone playing loud music. Quiet enjoyment means if I'm your landlord and I rented an apartment to you, it's my building, but guess what? It's your space. I have no right to enter your apartment. I have no right to enter your apartment except for regularly scheduled inspection of the unit or if there's emergency, like water's leaking from your tub down below. Otherwise, they have no right to enter your apartment. That's what quiet enjoyment means. The next little paragraph, 2-line paragraph, you can highlight that too. The lease may allow the landlord to enter the property to perform maintenance, make repairs, or some other stated purposes. Now, tenant's permission is usually required, but they can't deny you. And you do have a right to go in there without notice if it's an emergency. So, last paragraph of this page, implied warranty of habitability. Highlight, put an X by the last paragraph of 253. Highlight, put an X by the first bullet on 254. Highlight all these bullets over here as well. You can put X's by it. The property must be in habitable condition, which means the landlord must make sure that there's heat in the wintertime. He has to make sure there's hot and cold running water. He has to make sure that the toilets are working. He has to make sure that the garbage is picked up. Landlord has to make sure that there's no infestation of rats and roaches and stuff like that. The property must be in habitable condition. Now, skip a couple of paragraphs where it says security deposits. Highlight, put an X by that. Well, security deposit is not the last month's rent. The security deposit is to ensure that the property is in the same condition less any ordinary wear and tear. I mean, if someone lived there for 3 years, there's going to have a worn out path, where they walked on. That's normal wear and tear. They got wine stains all over the rug. That's not normal wear and tear. Someone lived in an apartment for 3 years. When they move out, chances are it probably needs to be repainted. That's normal wear and tear. Having a bunch of holes punched in the walls, that is not normal wear and tear. Now, that's what security deposit is. Now, the next paragraph starts with Illinois lessees. I already mentioned that to you earlier in this chapter, so highlight, put an X by that. Again, if you have more than 25 residential units anywhere in the state of Illinois, you must pay interest on the security deposit if you're holding a security deposit once a year. Again, if you do not, you could get fined 3 times what the security deposit is. So a lot of landlords are getting away from this, and what they're doing is doing a non-refundable move-in fee. Non-refundable move-in fee. It's getting quite high now. Right now, it's only started being a couple $100, but now it's over. It's around $900 per adult. Now, one thing you gotta make sure of as a licensed agent, make sure the security deposit and the non-refundable. Make sure that the non-refundable move-in fee will be the same thing as the rent.
because now it kind of looks like it's security deposit. That's paragraph improvements. Highlight for the X by that one. Neither the landlord nor the tenants are required to make any improvements to the leased premises, but if the tenant makes improvements with the landlord's written permission, any improvements made by the tenant now belong to the landlord. Again, want to remind you, anytime you add anything to real property, becomes part of that real property. The very bottom, assignment and subleasing. So this is going to go on to page 255. I like you to highlight the first two paragraphs on page 255, where it says this is under assignment and subleasing. So let me explain this. I rented an apartment to you. I rented an apartment. You signed a 3-year lease. After living there for 6 months, you found out that you're being relocated to another part of the country, but you have a right to sublease the apartment. I'm talking about a sublease. Now, in a sublease, the new tenant is primarily responsible for paying the rent. If the new tenant doesn't, you are still liable for the balance of that 3 years. That's what a sublease is. Now, you signed a 3-year lease with, and after living there for 6 months, found out you're being relocated to another part of the country, but you have a right to assign the lease. In a assignment, you sign a lease to a new tenant. The new tenant only is responsible for paying the rent. You are completely off the hook. In chapter 12, we talked about assignment and novation, if you remember that. Assignment is substitution of one person in place of another. That's what an assignment is. And you are off the hook. Towards the bottom where it says discharge of a lease, says a lease is just discharged when a contract terminates. That's the best way of terminating a discharge in a lease. All the parties fully performed their obligations under the agreement. Or maybe they might have agreed to cancel the lease itself. So let's go on to page 256. Now, in the middle of the page, a lease may be terminated by operation of law, like in a bankruptcy or condemnation. Now, breach of a lease. The tenant defaults on a payment of rent. The landlord has two options. Actually, just put an X by the first bullet. You can highlight the second, but just put an X by the first one. They serve a 5-day notice. 5-day notice says pay or quit. They're not out in 5 days. Now the landlord needs to go and file for a hearing with the judge. Now, generally, at least in Cook County, it would take about 2 to 3 weeks to get a hearing. That's all it takes, about 2 or 3 weeks. Now you have a hearing, and the tenant generally is given, on the average, about 7 days to get out. Now, if they're not out in that 7 days, then you go back and you file for what's called forcible entry and detainer. This is where the judge will order the deputies to come and carry out the eviction process. Now, the problem with that is sometimes the county is backed up of getting deputies out there to evict a tenant. That's why there's a delay more than anything else. Now, landlord's remedies, very next paragraph. It's called actual eviction. If the tenant breaches the lease, the landlord must file actual eviction. And again, the last paragraph highlighted X by that. Court issues a judgment for possession to the landlord, and then it's carried out by the deputies, by the county deputies. So let's go on to page 257. In fact, what I just said, the first paragraph, first, second, and third paragraph, you can highlight put X's by in 257. I already mentioned this very recently, just now. In Illinois, landlord seeking actual eviction
of a tenant must file an action called forcible entry and detainment. And then the judge will then order possession back to the landlord. And then if they're not out, then there's a eviction order issued to the sheriff that's carried out by the deputies. Actual eviction, that's when the tenant breaches the lease, that's what the landlord files. But the very next paragraph in the middle of the page, tenants remedies, constructive eviction. You can highlight for that X by that one. Tenant remedies, constructive eviction. So let's say the landlord breached the lease. I rented an apartment to you. You signed a 3-year lease with me in June. You moved in June. Well, you now find out October, November, December, I have no heat in this building. You cannot live in the Chicagoland area without heat. You're going to get sick. Your family's going to get sick. Well, you just can't move out. If it's not habitable, then what the tenant must file is called constructive eviction. Once a tenant files constructive eviction, now the tenant can move out, and now they're not responsible for paying the balance of that rental lease. So, I want you to know this. If the tenant breaches the lease, the landlord files actual eviction. If the landlord breaches the lease, tenant files constructive eviction. They should not move out till they have construction eviction filed. Okay, now, this stuff on page 258, this is regarding rental planning services. You can kind of go over those on your own. Referral services towards the bottom of 258. Actually, we talked about this once already. I'm going to talk about it again. So you got to highlight, put an X by the last two bullets here on page 258 and the one on top of page, the 2 lines on top of page 259. So let me explain something. In order to do any real estate activity, you need a real estate license. Now, the exception is if you own your own property or you're resident property manager, you don't need a license to do so. But a tenant can help a landlord rent apartments in their building. They as long as they can't do more than 2 referrals. They cannot earn more than $5,000 or 2 months of their own rent, or 3 referrals and 2 months of their own rent in any 12-month period. So a tenant who's unlicensed in real estate can collect a referral fee, helping out the landlord rent an apartment, cannot exceed $5,000 or 2 months of their own rent in any 12-month period. That, my friends, is the end of chapter 15. So again, I need you to do the chapter quizzes. We're almost done now. I got one more chapter left to do. We're almost done. And make sure you do the chapter quizzes. If you have any questions on this particular chapter, always contact your instructor to answer it for you. If for some reason you can't, then I'd like you to contact the school, email Danielle or Kimberly, Kim, and ask them to forward back to me. Okay. So again, this is Sam Zakarian. Wishing all of you the best of luck. I'll give you some tips on the next 2 more sessions from now. So looking forward to working with you in the real estate business. Until I see you on the next session, I'm going to sign off. Thank you all very much.